So Les Morley has been practicing immigration law in Kingston since 1988. He's past president of the Canadian Prison Law Association, of the Frontenac Law Association, and of Kingston District Immigrant Services, and is the current president of Kingston Employment and Youth Services, which is the largest immigrant services agency in the Kingston area. He's also an active member of the executive of the Ontario Bar Association's Citizenship and Immigration section, a member of Legal Aid Ontario's Prison Law Advisory Committee, and of LAO's East Region's Area Committee. He has served as a designated representative for mentally ill immigration detainees in Eastern Ontario for the past 15 years. So Les, come on up. Thank you so much for being here.
You put my coffee here. I'm not gonna screw up your laptop. Just a little bit too much blood in my coffee stream. Thanks for the invite, Christine, Julie, Victoria. Thank all of you for coming. I very much appreciate that, as I'll explain a little later. I think it's very important that as immigration lawyers and criminal lawyers, we have more dialogues than we do. I appreciate the organization of this one so we can sort of spread the message, the kind of devastating consequences that can flow from inadmissibility determined within the criminal context. And I'd like to tell you, relevant to that, a story about a man named Manuel Rodriguez. At least that's what I'll call him. And it's mostly true. The story is mostly true. I first met this man in the 90s. And I met him at Kingston Penitentiary, which was built in the 1830s, essentially a medieval iron and stone dungeon, just recently closed. But as bad as the sort of physical environment of the institution was the environment they had there of hostility and repression that perhaps was somewhat related to the physical environment. And when I first met him, I was on one of the ranges, and just to look at him, I could see that this was a man who was beaten and, I mean, exhausted and heartbroken at his circumstances. He was from Central America and had, as he was to relate to me, a horrific sort of upbringing. He came of age in the era of the Civil War in Central America. At the age of about 10, he was captured by the anti-government guerrillas. And essentially raised by them. So he wasn't taught to read or write. He was taught from an early age to fight. And he was separated from his family basically when he was captured. He told of sort of a just heartbreaking story of having, after some years, been fighting with the guerrillas, sort of hand-to-hand combat with the military, against the military. Of having heard about his family having relocated to Honduras and being able to get a bit of time to go and see them. And after having sort of been reunited with his family, the guerrillas coming to get him back, and a pitched battle in which people died with knives, he said swords, basically fighting it out so he could stay with his family. Long story short, he was able ultimately to obtain sort of refugee protection and relocate to Canada, where he was able to get permanent residence status, and he settled in a part of the west of Canada. And as often happens with people in that situation, he was still haunted by his experiences as a younger person, the things he'd seen, as so many refugees are. If you really sort of sit down and talk with them, the stories that you gather, just terrible. And he dealt with his demons by self-medicating, and there was alcohol and perhaps some other kinds of substance abuse. Long story short, again, he got into some criminality, and that's how he found himself in Kingston Penitentiary. And when I met him, he had been ordered deported, and he had been found to be a danger to the public in Canada, which is code, immigration code, for basically waiting for your sentence to end so you can be shipped back to where you came from. So he had essentially lost his permanent resident status, which is the consequence of a deportation order, and he had lost his refugee protection, which is the consequence of a danger finding. And he was just waiting for his inevitable return back to a situation which, of course, in his mind was akin to basically death. And separation, of course, from his family. He was able to join him out west. So I came to represent this man, and I observed that unfortunately he had a counsel, but he didn't at the end. By the time that the proceeding had got to the point of plea and sentence, and he represented himself, and he got a penitentiary sentence. And he found himself in this situation. And it occurred to me then, and it's occurred to me many, many times since, that had there been a criminal counsel, and had there been a dialogue between criminal counsel and somebody who could provide some context on the immigration side, that there might have been a different story told. For instance, a plea bargain might have been made that might have insulated him from the consequences of the criminality, because at that time it was a 2-year threshold for denial of an opportunity to go to the immigration division. There might have been arguments possibly even made before the deportation proceedings commenced. There might have been a split sentence over multiple counts that might have insulated him from some of the issues that ultimately transpired. And so what we had to do is we had to go to federal court and get the danger opinion set aside and create a situation where we could get the matter in front of the Immigration Appeal Division, argue a deportation appeal, and ultimately it did have a happy ending, but many don't. And this is a sort of a historical thing I'm talking about here. The options that ultimately that we were able to realize for this man are not available in the same way today as they were back then. In fact, when I first started practicing, I had clients who were convicted of murder, and we went to the Immigration Appeal Division, and we argued that in one memorable case for me, it was second degree, but not first degree, but we were able to convince the maybe what I did was exhausted the Immigration Appeal Division, but we went on and on day after day, and with testimony and glowing testimony about how this young fellow had committed murder and completely rehabilitated himself, and the board was convinced. In fact, they basically told me to shut up. All right, we get it. So we'll stay the deportation order. And you'll hear, as you have already, about this 6-month threshold, and it's all about trying to get a hearing like that. Back in the 90s and before, everybody had an opportunity, even this fellow who was convicted of murder. But the opportunities for people in that situation, for your clients to make arguments, have been attenuated over time. They've been narrowed, and they've been narrowed further, and they've been narrowed further, until we got to the point in 2013, thanks to our good friend, Mr. Kenny, that we implemented a threshold of 6 months, which is actually one of the most strict thresholds that exist in any developed country, more strict than the United States with respect to criminal inadmissibility. So just to be absolutely clear, and maybe a little dramatic, and also truthful, I've had clients who have been here since the age of 7 and are now in their 60s and 70s and got their permanent resident status, didn't see or were too disorganized to be able to get citizenship, or perhaps too involved in the criminal culture, and were facing deportation when they basically hadn't been in their home country for decades. And in some cases, because I've had people who've been under the age of 1 when they came to Canada, who basically don't even speak the language of the country that they are from. But in all the world, the country that you've got citizenship is the only country you can be deported to. So if you come from Afghanistan and you came in better times and now you've committed crimes, this is Afghanistan you'll be deported to, because there's no other place that's lining up to welcome you to their country. So it goes. I can tell you, no end of stories about these kinds of difficult situations. I would like to mention that more than once I've had people. This was before 2013. Mr. Kenny's gift to all of us in the Faster Removal of Foreign Criminals Act that dropped the threshold from 2 years to 6 months. I can tell you that I had situations where clients talk to me about having plea proposals by the Crown Attorney of 18 months, but having made a calculation in league with their lawyer, their criminal lawyer, to get 2 years, because then they would be able to be in a penitentiary with access to the enhanced programming available there and a more robust parole system that might get them out of jail much earlier than they might have been in the provincial system. And so what they had done effectively is they had, by going for a 2-year sentence as opposed to the 18 months that was on the table, they had put themselves in a situation where they are now going to be deported. So, it's kind of a situation where possibly the battle was won, in the sense that a more attractive kind of sentence seemed to be in place, but the war was lost because now one was going to be enjoying one's post-sentence time in another country. And deportation, just to be clear, deportation means not only that you lose your permanent resident status, and obviously that you have to go, but it means you can't come back, and you can't come back forever. There are procedures that can be employed to try and make that case, but as you might imagine, it's tough slogging to try and make them happen. And another theme I'd like to be heard, I guess, is that in immigration law and inadmissibility law in particular, time is on our side while our clients are in Canada, but obviously once you're deported, time is very much against you. Time passes, you get more established in the country to which you've been deported, and there's less of an argument to make to come back to Canada. So we fight like the Dickens to try and get people to stay here as long as they can. Because once you realize, I did something stupid, I'm in trouble, the longer period of time until the actual date of deportation, if it comes, and you hope it doesn't, the more time you have to try and improve your situation, as I will detail in a few minutes. So I'd like to talk about a couple things today. I'd like to talk about criminal and immigration lawyers, a little bit about the immigration law basics. I know you've heard all this, but we'll go over it again, maybe a little bit of a different way. And then some things that you can do to reduce the immigration impact of your client's criminality. My big message to you is to be proactive, to find out, as Christine has very rightly mentioned, find out if your client is an immigrant. I'm sure all of us realize it's more than just looking at the guy and saying, "You look like an immigrant to me." I'll tell you. That's right. That's right. First of all, you should ask him. But as Christine pointed out, a lot of times people don't know, and that seems pretty strange. But think about your clientele. You know, if they let's be honest here. If they were forward-thinking people, they might not have chosen to get involved in criminal activity. You know, people don't always know, and it's not always so easy to know. I had a client just recently, in a really sort of tortuous, complicated case, who told me he was a refugee. He swore he's a refugee. In fact, what happened was he came to Canada. This was during the Yugoslavian debacle in the 90s. He came to Canada on a visit, and things went to hell in his country very quickly, very rapidly, particularly for people in his situation. So they just basically stayed here as refugees. So it made sense when he said he was a refugee, that and with the timing and everything, that's the case. But we looked into it a little further, and we determined, in fact, he wasn't a refugee. How could he come as a visitor and stay here if he wasn't a refugee? Well, because at that particular time, the immigration authorities had created a class of people that they were prepared to give status to outside of the refugee process. And these people, as a class, were allowed to remain and to apply for permanent residence within Canada. This also happened with a number of people after the Tiananmen Square massacre in the late 80s, I believe, that all the Chinese students here were given an opportunity to stay if they wanted, but they weren't actually found to be refugees. They were given kind of a protection in contemplation of that type of concern. And so, like, big diff, what does it matter? Ultimately, my guy got permanent resident status. Well, it did make a difference because, as we'll hear from Laura later, if you're a refugee, you get a certain type of protection. You get a protection beyond your permanent resident protection because basically there's a force field around you and you can't be removed. You're protected from removal. And this is not simply a matter of Canadian domestic law, but also of international law to which we have subscribed. We've committed ourselves to protecting people in that situation. But the Refugee Convention says that there are certain circumstances in which refugee protection can be overcome. And in cases of serious criminality, defined under our law as being a danger to the public, that can happen. So in this particular case of this client from Yugoslavia, we thought we had a danger proceeding that was going to protect him because they take an awful long time to work their way through. Years sometimes. I've had a couple that went on for 3 years. The timing then suggested that we were going to be going through an admissibility hearing and then a danger proceeding to take away his refugee status, but he never had it. So this fellow who has been in Canada for close to 30 years, thought he was a refugee. He wasn't a refugee, right? And everybody around him thought that because it was sort of a technicality of the way in which he was protected. So find out from the guy, ask for the documents. We've heard a little bit about what the documents are. Ask for those documents, put them in your file. Do some due diligence on that. Follow up with a letter as to what the client has told you about his status. Put it in your retainer agreement. consider referral to an immigration lawyer if there's any question about it. And I've just explained a situation where, you know, a lot of immigration lawyers would have concluded that the person was a refugee if they'd heard the story and hadn't confirmed by looking at the documents. Also put it in your reporting letter as well. And I guess what I'm trying to say here is, as the big message, is to incorporate immigration consequences into your strategy as you develop a strategy for your immigration files. I think we're probably all in agreement on that, or we wouldn't be here. But it's really important to be thinking that way. Just a few words about me. I began practicing in 1988. I've always been in Kingston. I always wanted to practice immigration law, but there's hardly any immigrants in Kingston, so that was a bit of a tricky thing to do. I found most of them were in jail, actually, so we have lots of jails in Kingston. So that caused me to get into the inadmissibility part of it. Yeah, we've got thousands of people in jail in Kingston. So, and actually, it kind of got me hooked because these stories are just unbelievable as I'm trying to communicate to you. And initially, I did all sorts of other kinds of law as well. Real estate, you know, corporate, lots of family law, a lot more than I wanted to. But ultimately, over time, I was able to refine that down to immigration law. And over time, I was reminded again and again and again, wouldn't this situation with my client have been better if I had an opportunity to talk with the criminal lawyer at the time that the matter was being adjudicated in the criminal courts, and it seems I've got my wish because I've got this opportunity to speak to you today. As I say, very appreciative about it. If I just might take a minute here, by show of hands, are there any of you who are from outside of Halifax? A few of you? All from Nova Scotia, or if there's anybody from maybe New Brunswick or PEI? No
I think we've
immigrants
got
there.
some New Brunswick people coming tomorrow.
Really?
Yeah.
Is that right? Okay, well, that's interesting to know. And some Crown attorneys too? Yeah, yeah, a couple of Crowns. You know who we are. Okay. Yeah, good. Okay. Well, we're all together on this particular project. It's all kumbaya with us. And did I hear somebody here that was making a comment that suggested they might be practicing immigration law? Is there anybody here that's doing some immigration? Yeah. And what kind of work are you doing?
All immigration streams, including sponsorships. Not that much recently, but planning to get involved again. To volunteer in the clinic.
Inadmissibility stuff too?
I did in the past, and I came from former Yugoslavia as a refugee. So,
You did.
yeah, 25
Check
years.
your papers.
Yeah.
Check your papers. What about you? You practice immigration law too?
Yeah, I do. Almost completely immigration.
Okay.
Yeah, all different sorts. Oddly, right now, a lot of spousal sponsorships,
Yeah.
but occasionally inadmissibility. I'm in like a full-service firm, so the lawyers who do criminal are frequently knocking on my door to ask what happens.
Yeah.
Um,
It's a growth business, right?
Yeah.
There's no end of potential customers. Okay, thanks. And nobody else practicing immigration law? Oh, yeah? What kind of stuff do you do?
I do pretty much everything.
Everything.
Criminality, also all the other ones, temporary residence application.
General practitioner. Good. Is there anybody else that's on? Yeah? Some immigration stuff? Refugee claims? What do you do?
All immigration, refugee, just economic,
Everything.
humanitarian.
Everything. Okay, so there's a little bit of an immigration bar here in town. Yeah.
Yeah, and I was saying this earlier, so there's legal aid doesn't cover immigration and refugee matters in Nova Scotia, and our clinic works with volunteer lawyers. So you have lawyers representing clients in immigration proceedings who aren't necessarily immigration lawyers. So this is really important to know about it.
Well, you may be, I don't know how you react to this, but in Ontario it's different. We have legal aid certificates for immigration services. I mean, we complain about it, but you know, you get 16 hours plus hearing time to represent a refugee or to do a humanitarian compassionate application. Danger opinions are, as Laura will explain, are woefully underfunded, but you get paid something at least. I mean, it's not worth doing, quite frankly, for the fee that they give you, but it happens. As it turns out, you know, we're probably the best off of the different legal aid systems, I believe, in terms of the coverage we have for immigration matters. So I'd like to talk a little bit about criminal immigration lawyers. We have a lot in, most of you are criminal lawyers, I'm gathering from our conversation a moment ago. We have a lot in common, the two kinds of lawyers. We're both interested in sort of state versus individual issues and rights. We deal in an area of the law that's subject to vigorous public policy debate and political manipulation, choosing, depending on your point of view and your political bent. I know in the last government, before the current government, there's something called an operational bulletin, which is a sort of an advice on how to do things from on high that is like a policy guidance. And they were coming out at the rate, it seemed like several a week, whereas traditionally we would have a few, a dozen a year. So when the political situation gets hot, it gets hot for immigrants pretty quick, as it does for those in prison and as it does for criminals. Also, immigrants are subject to detention in certain circumstances, so we share that in common and sort of bail type considerations, imposition of binding conditions and how they breach of those conditions is dealt with. And we also deal with deportation, which, you know, from some perspectives might be considered to be a kind of punishment. I mean, traditionally banishment was sort of the worst kind of punishment that there was in traditional societies. And it's interesting that a significant United States Supreme Court dealing with issues with respect to representation on immigration issues in the criminal context spoke of deportation as a particularly severe penalty. It's not been regarded that way under the charter at this point, but it has kind of punitive aspects to it. Despite the commonalities that we have as immigration and criminal lawyers, we have a lot of differences, and I'd like to underscore some of those because I'm hoping that that one of the consequences of today's and tomorrow's proceedings will be more dialogue between criminal and immigration lawyers. So the first thing is that we kind of speak a different language. We define seriousness of offenses in different ways than criminal lawyers do. You talk of summary and indictable offenses, but those distinctions are irrelevant to us, except if an offense is purely summary and has no indictable component. Electable offenses are deemed to be indictable, and as you know, the vast bulk of offenses under the criminal code are electable offenses or straight indictable. We talk in terms of criminality and serious criminality. Criminality affecting temporary residents and serious criminality affecting also permanent residents. So a much more sort of substantial consequence. That's how we divide up offenses. Our standards are different as well. We haven't heard about that yet today, but it's important to take note of. You deal with proof beyond a reasonable doubt, but we deal with the balance of probabilities or reasonable grounds to believe. So this is why it's so important that we get the criminal record straight, because once a criminal conviction's happened and the sentence has been imposed, it's only necessary for the immigration division member who's considering whether a person should be deported or not to have reasonable grounds to believe that there's been a violation of the criminal law of the sort described. So reasonable grounds to believe is not even a balance of probabilities. It's simply a much lower standard. It's been defined as falling short of a balance of probabilities, but connoting a bona fide belief in a serious possibility based on credible evidence. That's reasonable grounds to believe, and that's all that's needed for an admissibility finding. So an admissibility hearing where the deportation order is at issue is, generally speaking, a foregone conclusion. It's at the appeal stage where there is access to an appeal that you get to talk about equities, where you get to call evidence. And I mentioned earlier that there was a fellow that we were going on day after day with his deportation appeal hearing. There's no limitation. The appeals hearing, which is really something that you see so much of as a subject of appeals to the courts of appeal across the country. It's really about getting that access. It's that 6 months threshold. It's really about getting that access to a hearing where you can really talk about why the guy should be allowed to stay in Canada. Somebody who's been here for 60 years, I think most of us would agree, probably their criminality is really a part of their Canadianness, and deportation away from their family where they've lived all their life is a pretty draconian kind of result. But unfortunately, if you've only got an opportunity to appear at an admissibility hearing, it's irrelevant. It only becomes relevant when you get to an immigration appeal division hearing, a deportation appeal as we call them, where you can raise these kinds of issues and you can testify about why you're sorry and why these bad things that you did don't really represent who you are in total. Also, with respect to criminal and immigration lawyers, we define success differently. Often getting through the system quickly with a quick deal is a good way to go for a criminal lawyer. A plea that gets a person a short, sharp sentence may be a great result, but it's not necessarily such a good result on the immigration side, where we like to take a little bit more time and make sure that the record is good, that is what the judge says when he's pronouncing sentence, the facts that are read into the record, all of those things that can create part of the record, the actual indictment, the annotations of the court on the indictment or on the information if it's dealt with in provincial court. All of these things form part of the record, and if they tend to be rather negative, or then you can be sure that the immigration authorities will seize on that. Also, as Christine alluded to, we're much more clash conscious as immigration lawyers than criminal lawyers are. It doesn't really matter, or it shouldn't matter, about who you are when you're facing criminal penalties or the criminal law. But in immigration, your status is really very critical. And we've heard about citizens. Citizens are generally immune to removal for criminality. Permanent residents are potentially removable if the sentence is serious enough, as we've heard. Refugees as well. Temporary residents meet at a lower threshold. People with no status are also another class of person. And also something we haven't heard about is some people with conditional status, people who've gone to an immigration appeal division hearing and been successful and been granted a stay of removal, like a stay of execution of the deportation order. They are another class of people that where there are certain implications for the decisions that are made at the criminal court for the person who's subject to a stay. And we're not dealing with foreign offenses here, but it's worth noting that they're very significant for us on the immigration side, whereas they may be of much less significance to you on the criminal side, and probably not a subject of conversation at all. But it is possible for a person to be inadmissible to Canada because they committed an act in another country that would be criminal there, even though they weren't convicted, and would also be criminal here. It seems crazy, I guess, to a lot of criminal lawyers that such a thing could be, but ironically, an overseas diversion process can be fatal for admission to Canada, because by getting diverted or getting a discharge, in some cases, depending on the way in which it reads and compares to our discharges, you've admitted the offense, and even though there wasn't a formal finding, if there's an admission of having done it, that can be used against you and keep you out of the country. So, so there's some differences in the way we look at things, immigration lawyers and criminal lawyers. It's important to remember that. I want to say a few words. I'm not trying to scare you, but I can tell you that that in the United States, 2010, there was a Supreme Court case, Padilla versus the Commonwealth of Kentucky, which provides some guidance about where things may go ultimately in Canada. I haven't quite gone there yet, but they might. Mr. Padilla was a longtime lawful resident of the United States who was charged with transporting marijuana, and his criminal lawyer said, you don't have anything to worry about on the immigration side. He'd been in the United States for so long. But this was actually wrong, because deportation was actually virtually automatic. So, so when this was discovered, Mr. Padilla appealed, but it was a matter of sort of bad advice, and how that played before the courts didn't really the story didn't get fully told until it got to the Supreme Court of the United States, which held that lawyers must advise of the collateral consequences of convictions. And if the law is unambiguous, attorneys must advise their criminal clients that deportation will result from a conviction. And if the immigration consequences are unclear, attorneys must advise that deportation may result. Counsel cannot remain silent about immigration, and judges don't do that either. If you've ever had an opportunity to look at transcripts of U.S. Plea proceedings, there's a whole litany of different things that are the person pleading guilty is advised of by the judge, including immigration consequences. And here in Canada, we haven't a decision quite like that, although there was the Wing Wah Wong decision that went up to the Supreme Court of Canada in 2017. And it was decided sort of ultimately on other grounds, but was about the sort of liability of immigration of criminal lawyers for immigration advice. So I think another case like that is probably coming at some point for those people that don't attend sessions like this, of course. So, and in Ontario, we have something called Law Pro, which is our insurer that insures for professional liability Ontario lawyers. And a recent bulletin there said, quotation marks here, lawyers who fail to appreciate the immigration consequences of criminal convictions can leave themselves open to allegations of malpractice. So there are consequences or potential consequences for not developing an immigration strategy from the outset. So in practical terms, it means criminal and immigration counsel need to talk. questions about any of that stuff? Before I move on to something else? No? Okay. All right. So, immigration law.
I can ask a question.
Yeah.
How frequent it is that people don't get the blended advice or integrated?
It's-
Is it really something that is really problem,
Well,
systemic? And why?
it is. I would say it's less of a problem than it was, and it's coming up. But sometimes criminal lawyers don't even know, right? They don't know that the person's an immigrant. It's not clear. I had a case just recently. A person was convicted of impaired driving causing death, and nobody picked up on it, including immigration, for the longest time. It wasn't understood. There was nothing to sort of clue in anybody, because the person had a sort of they were born in the States, and they had for all intents and purposes, there's nothing to trigger any sort of concern. So it's something, and we have a lot of immigration from the United States, so it's something to be aware of in every case. And even although there are more people now, more criminal lawyers who are aware of these issues than there used to be, there is a sort of sophistication to the kinds of, and complexity to the issues here, as I mentioned with respect to the person from Yugoslavia who was actually not a refugee. So understanding the status, understanding some of these issues that are critical to immigration law is really, really important as you formulate the sentence. Also, for instance, it can be as simple as this. I had a client married to a Canadian. I still have this client. And my our agreement, the criminal lawyer and mine, were make this go on as long as you can, basically. Stretch it out, because we have some work to do. And the reason for that was, first of all, there's that sort of first commandment of inadmissibility law I spoke of, which is that the longer the person's here, the better their chances are of being able to stay here. But ultimately, there were going to be immigration consequences to what was happening to this woman who was facing some criminal charges. But if we had a year where we could get her involved in programming, where we could start putting together letters of support, affidavits, where we could make a pitch, then in that immediate aftermath of the conviction we were anticipating coming, we could make an argument that maybe she not face immigration consequences at all, that it sort of should be diverted. I think there's going to be a discussion about this tomorrow, maybe,
Yeah.
844 proceedings. Yeah.
December.
So there is a process of probably minimal interest to you guys, but it's kind of like this. It's kind of like, if you got a call that a good client or a good friend of yours had been the subject of a complaint from a neighbor because he and his spouse were fighting, and they were down at the police station now, and you were able to run down to the police station and talk to everybody, talk to the police, talk to your client, talk to the spouse. You might be able to work it out without a charge being laid, because there just wasn't any public interest in doing that. And there are times when you can do that also on the immigration side, but you can't do it quickly. And if the charges are more than minimally serious, then it's tough slogging. So to have that extra amount of time to develop the case can be really, really, really helpful. So it's also about the timing of things that you want to get some feedback from the immigration side as well. And also, of course, life goes on, right? Perhaps you graduate, you get your master's degree in that year while you're facing the charges. With this new focus you've got on, okay, maybe I should pull up my socks. Or maybe you have a kid and now there's a Canadian-born child, or you get married and you weren't married before. So now you've got some arguments that you didn't have before, if you've got that extra time.
Does the Crown has any duty?
Pardon?
Crown? Prosecution? Any duty on their side?
Well, yeah, I mean, Crown attorneys are speaking on behalf of all of us, really. And, we are a compassionate people, I believe. The Supreme Court has pronounced on the fact that collateral consequences, immigration being one of them, are a factor to consider. They're not determinative in every situation, but allow the Crown attorneys to speak. But I in my experience, where the immigration consequences are laid out, this isn't going to turn a 3-year sentence into an absolute discharge. But there's a range. There's always a range, and with the appropriate Crown attorney and the appropriate facts, you can make it work.
I'm a regulatory prosecutor, so I do business prosecution. The reason I'm here is I do volunteer work at the Refugee Clinic. But with any kind of prosecution, any kind of sentencing, you look at all the different factors. So even if it's something like a corporation that's being prosecuted under the Environment Act, one of the considerations might be a certain kind of conviction might preclude that company from marketing their wood internationally, and that would be too significant a penalty. So there are always a wide range of considerations that a prosecutor or a court ultimately has to take into account when they impose a sentence. And in Canada, certainly in all areas, environment is a good example, but in all areas, there's more and more impetus for creative sentencing. In fact, I have to leave a little bit early to go to a lunch hour session where Judge Tax of the Windsor Court is talking about creative sentencing. So it's certainly something that is in all levels of sport, in all kinds of matters. And
So that's the thing.
you look
Creative
at why-
sentencing is
yeah.
a subject.
Absolutely.
And interestingly, on the immigration side, what we're seeing is less and less discretion. So I've been around long enough to have seen the evolution from, I could take my client convicted of murder and have a shot at being able to allow him to stay, to now some guy with a break and enter gets a 6-month sentence and they're toast, although they've been here all their life. Toast in the sense that there's really, unless they start, making some written advocacy, they're not going to get a hearing. They're not going to get a hearing in equity about anything. So it's we're seeing on the immigration side less and less discretion, which is why it's so important, particularly with creative sentencing being a thing, that we tap into the potential there to make our lives easier as immigration lawyers and our clients' lives easier as well. So a few things. First of all, immigration law is set out in not only the Immigration Refugee Protection Act, but also in the Immigration and Refugee Protection Regulations, which are much more extensive than the Immigration and Refugee Protection Act. But they're also set out in procedural manuals, which are all published online, by the way, and just hundreds of pages of stuff for you to sort through. And then these operational bulletins I spoke about, which at some points were coming out on a daily basis. Also case law, which in immigration terms includes the Federal Court, the Federal Court of Appeal, the Supreme Court of Canada, which is not surprising, but also the Immigration and Refugee Board. Sorry, what was that? Okay, thank you. The Immigration Refugee Board, Immigration Appeal Division, Immigration Division, Refugee Appeal Division, and Refugee Protection Division. All of them produce decisions. You can find many decisions in Canada. So I'm going to zip through some of this to move on to some tips. So what do you do? What do you do if you've been alerted that you've got potential immigration consequences for your client-facing criminal sanction? First of all, if you can, obviously get the charges dismissed. No secret there, but the stakes are a little higher, so you may want to do some calculations, obviously with your client's informed consent, about whether you run a trial where you might otherwise have done something quick in terms of a plea. You may want to, as I say, set a trial date so you can give a long time, get the guy finished his study in Canada, so he's not going to get deported until after his studies are over. You might see if you can arrange with a generous Crown attorney a withdrawal of charges, or get diversion as well, or if there can be a MCR judgment, that can be good, or a peace bond as well is also a useful resolution of these criminal issues. But where we see this most particularly, and certainly in Ontario anyway, is in mental health cases and in domestic violence, and to a certain extent in substance abuse cases. There are diversion processes that can be really important. I remember when because I did a little bit of criminal law back in the day, when I was told by senior practitioners, you know, if you plead not guilty because the person's not criminally responsible, they'll be tied up for God knows how long, and that will be, you know, they're much better off just simply make a plea and throw themselves on the mercy of the court. Maybe they get a week, or maybe they get 2 weeks. A lot of times, the mental health cases I've dealt with, people with schizophrenia, they're in and out of group homes, living on the street, using drugs. There's lots of not reporting offenses, lots of possessions, lots of thefts, minor, minimal stuff that seems like it isn't of significance, but over time it adds up. And then it comes to us as immigration lawyers, and we're looking at a guy with 30 convictions, all of which stand for the notion that he was criminally responsible according to the law beyond a reasonable doubt, you know. And in fact, if the calculation was, let's get him out of jail quickly, this is my client's instructions, I don't want him to be found not criminally responsible because he's going to be, you know, tied up in a psychiatric facility for a long time or something. You know, you may want to consider the immigration consequences, particularly in a circumstance like that. Getting your client out of jail on bail is another tip I would have for you, and the reason for that is that, first of all, in custody trial dates, at least where I come from, in custody trial dates are usually prioritized and set more quickly. Is that that's the case here too? Yeah. So if you get the guy out, then you've got maybe a year till trial, at least where I come from, and that's lots of time to do something good. You can always plead at the end, it's not with appropriate notice, but in the meantime you get to accomplish something. Also, you're reducing this ticking pre-sentence custody problem, because I'm not sure how the judges are doing it here, but there were, you know, not so long ago, pre-sentence custody was up to sometimes 3 times the amount of time actually being served. Now I think it's 1 to 1.5 usually the amount of time being served, but it can quickly add up. And while I have heard judges say that they can ignore pre-sentence custody, they would be prepared to do that. I've also encountered those who felt that it's not really something that they should do because it's really part of the punishment. It's part of their consideration, and everything that's part of their consideration they need to state in open court. So if your guy's in for 4 months and he's got and that time was counted as 1.5, or when he's already hit the 6 months, and it doesn't matter what the sentence is, he's already out of luck. So get him out of jail if you can. Plead criminal offenses down to provincial offenses. There are a few that might work. If you've got dangerous driving, I guess you're aware that at least under the Ontario Highway Traffic Act, you can sometimes knock that down to careless driving with the right negotiations. Get an absolute or a conditional discharge if you can. I mean, a conditional discharge, of course, means there's probation, so there can be strict terms of probation, there can be heavy terms of probation, but still be a conditional discharge. And then once at least immigration processes will be suspended during the course of the probation, but at the end of it, then there won't be any. Because ultimately, it'll just be registered as a discharge. Try to plead indictable or electable charges down to straight summary offenses. There are very few of those left in the criminal code, but there are some. For instance, an assault charge might be pled down to cause a disturbance by fighting, which would be straight summary, and therefore doesn't expose the person to, like a permanent resident, doesn't expose them to any consequences. A break and enter might be dealt down to a trespass at night. I know that seems like a big ask, but with the right facts, it might happen. Plead your offense down from one with a maximum penalty of 10 years or more to one with less than 10 years. So you get it out of the serious criminality realm. Insulate your client from immigration consequences. You can charge more for that. He doesn't need an immigration lawyer after that, so it's really in your interest. Think about it. So we have a big change from our immigration bar perspective as of December 18th, with impaired driving now having a maximum penalty of 10 years. And this is, I think, one of the most frequently laid charges under the criminal code. And it's now having immigration consequences for permanent residents. So they could potentially be deported. Now, on their first impaired, is that going to happen? Well, probably not. But it's just a big hassle that they don't need. Pleading an impaired charge down to something else is tricky to do, but it may condition whether you want to go to trial or not. I just want to comment on something that we heard earlier about whether 6 months exactly is an issue or more than 6 months is an issue. It has to be more than 6 months for you to be inadmissible, 6 months in jail. But the threshold for an appeal is 6 months, includes 6 months. So that's why we always want to go to 6 months less a day, because you are not then inadmissible, but also you have the possibility of going to the Immigration Appeal Division. So maybe you can play off a few things like, okay, let's knock the sentence down a bit, but we'll make restitution, full restitution, we'll pay a big fine in addition, or we'll get a longer term of probation, but get that sentence down under 6 months. As we've heard, a conditional sentence is a good alternative as well, because they can be up to 2 years long and they're not considered to be jail time. So conditional sentence is a good thing to have in your arsenal if you're facing something that's going to be a little tricky to get under 6 months. And if you've got somebody with a kind of a spree series of offenses, maybe there's a whole bunch of shoplifting charges or some break and enters or robberies even, there actually are clients of mine anyway in the penitentiary now, so 2 years in jail or more, who have a right to an appeal. And the reason that they have a right to an appeal is because each of the sentences that they have served or that they were sentenced to in a sentence that's comprised of many convictions were under 6 months. So the Hennessy case, which I referred to in the top 10, one of the top 10 tips papers, was actually a case I was involved with. And what happened was the guy had got, I think, 4 years, maybe it was 3.5, something like that, for a bunch of robberies, 7 of them or something like that. And he got 3.5 years for each of them. all concurrent. And so we went to the Court of Appeal to say, let's redo that so that each of the sentences, at that time the threshold was 2 years, each of the sentences was under 2 years. And that's the threshold that's now been reduced to 6 months by Kenny. So, thank you. So that the sentence now became something like 7 months, 7 months, 7 months, 7, all added together to form the same exact sentence as it was before, the same length of sentence, but comprised of discrete consecutive sentences, each one to the other. And the consequence was no denial then of access to the appeal division. That, by the way, was a good example, that particular case, of collaboration between the criminal appeal lawyer and the immigration lawyer. Just briefly then, I will indicate that there are a few prison law consequences for being convicted as an immigrant. Offenders are not eligible for day parole until their full parole date. Offenders are not eligible for unescorted temporary absence passes. Like it's a kind of bizarre provision within the Corrections and Conditional Release Act. There is parole for deportation available for those who reach their full parole eligibility date. And there is a likelihood that you will be detained if you're doing a sentence of any length in immigration detention. We'll talk about this tomorrow. Upon the conclusion of your sentence. Imagine you get a sentence for 9 months. You're ordered deported. You will likely go into immigration detention at the conclusion of that 9 months. It's going to be a real tough going to get out, quite frankly, because you're being detained in contemplation of removal on that order. There are some things to do. There may be some work for you. I'm all about trying to give you guys some extra work here. There are criminal appeals that you can do. You're probably, many of you are aware that collateral consequences can be considered at the appeal stage if they haven't been considered at the court of first instance. So you can appeal a sentence, and as long as it's within the appropriate range and collateral consequences weren't considered, a sentence can be knocked down by the appeal court so that you get back within under the threshold that you're wanting to get under. There are other things that can be done on the immigration side: temporary resident permits, applications for criminal rehabilitation, submissions that can be made on humanitarian compassionate grounds, refugee claims can be made in certain circumstances, and submissions, as I've said, about not even having any immigration consequences at all. So again, I'll just return briefly to my main message here, which is that we need to talk together more as immigration and criminal lawyers. We need to have conversations so that we can help our clients to avoid the consequences that flow from the work that you have to do for the client's status in Canada. Any questions?
I guess.
Yeah.
I was just wondering if there's any move to roll back some changes in Alaska and agree with the directions with the hearings at the time.
Way into the realm of politics there. I think it becomes politically very difficult to do that because there was obviously some constituency for the tougher penalties, and then certainly not in the current environment. I wouldn't, And in fact, it's interesting the way this whole impaired driving thing went down, because it was really sort of in tandem with the we're going to allow marijuana to become legal to consume, so let's make the impaired driving a more serious offense. And so as a consequence, we've seen that even the current government has given and taken away at the same same time.
My question that you just answered is not more of a comment, and it was about appealing a sentence, and especially with what you were speaking about earlier, when an 18-month sentence, you would want to go for a 2-year sentence to be in a federal penitentiary, and before the faster removal of Foreign Criminals Act, it was 2 years less a day that you needed
Right.
to access the Immigration Field Division, and we've only done it once. It was actually Nova Scotia Legal Aid that did it, but it was a client of the clinics who successfully appealed the sentence from 2 years to 2 years less a day. So that just kind of showcases the importance of working collaboratively.
Yeah.
And that there are things that can be done.
Yep.
I mean,
Yep.
now it's 6 months less a day, so you couldn't get it 2 years sentence into.
I know, it's brutal.
And now there's trend.
So, is there any reporting system in place where justice automatically reports?
Where what, sorry?
Where the justice system, whatever part, reports to Canadian Border Service Agency. How is this inadmissibility really even started? Does
Yeah.
it automatically go there, or it's just at
Well,
discretion of?
Because the correctional authorities are sometimes better than counsel at making sure that they find out all of the information about the person that's in jail, right? And so they want documentation. They want so they additionally, when there is an arrest, there's usually or oftentimes there's a search and a seizure, and certainly in the more serious offenses of immigration documents, which then allow for the identification of the person as a potential immigrant. So then there's communication directly from them to the CBSA.
So what about permanent residents? Because they are also
Yeah, they're also
subject
exposed.
to
Yeah.
in certain cases. So
So
who don't even think about reporting it?
who what?
I mean,
CBSA.
making, like,
It's the same. It's the same
Okay.
thing. So the correctional authorities identify who it is that they're dealing with, and notify the Canada Border Services
it's all
Agency.
in place and part of the.
Yeah, and I think we're covering a bit of that this afternoon